You are listening to the podcast That's Life in Sweden, or as we say in Swedish, Sånt är livet i Sverige, with me, your host, Lisa Åsimäki. Today I want to welcome Associate Professor Lisa Flower from Lund University here in Sweden to the podcast. Good morning, and how are you this morning, Lisa?
Good morning. Yes, I'm very well, thank you.
That's great to hear. So, to start off the program or our conversation, can you provide a brief background to who you are and your initial reason to study in higher education?
I'm originally from England, so I did all of my early education in England. I did a degree in psychology, and then decided psychology, when I finished that, wasn't for me. So I did the usual thing of going backpacking and ended up meeting a Swede in Australia, and then moved to Sweden. So then I did a degree in social work to kind of learn about Swedish society, and as part of that, we had sociology, which I found particularly interesting. So I did a master's in sociology, which led on to the PhD.
Okay. Now, you wrote about, in your PhD was about the emotions of defense lawyers. I'm curious, why did you choose the topic? Are you a lawyer?
No. I have. I did read a couple of one course on law on the social work program, which I thought was very interesting. But I got into emotions and the emotions of defense lawyers through my master's program. So I did that at Gothenburg University, and I had also Wettergren as a teacher there on the course. And her course on emotion sociology I found particularly interesting and inspiring. Not just the subject, but also Wettergren herself is a very motivational teacher for me, and that led to me writing my master's on the emotion management of law students, and then that led on to applying to do a PhD focusing on defense lawyers' emotions.
Do you think are defense lawyers taught how to deal with emotions, especially when defending clients accused of heinous crimes, and being aware that, if you like, winning the case is virtually impossible?
Yeah, no, they aren't. I mean, when I did my my master's and I looked at how, I studied how emotions are discussed and talked about on law programs, then emotions weren't talked about or discussed. They were brought up in conjunction with certain areas of law, such as family law, or with regards to certain kinds of participants in trials like victims. But the legal professionals themselves, their emotions weren't ever talked about or taught. So instead, the teachers would also perform their role as teachers in a way that didn't really display explicit emotion, so that the students started to learn on law programs that this is how I should also behave in the courtroom. And then when they come into the courtroom, then they start to learn and start to become socialized into this way of performing emotions in the right way, and learning that there are these invisible and implicit rules for how you should feel and how you should show this. But it's very much something that's learned on the job once they come out in the courtroom and they see how other people do, and they start to learn when they've broken one of these rules. And by breaking the rule, then this rule becomes visible to them, and they start to realize, now I've done something that I shouldn't have. So this is what my my PhD dissertation focused on, was finding these implicit rules of emotions and how to interact. And with regards to not knowing or not winning any cases, I think they in the interviews that I conducted with them, they use emotion talk. So they talk about winning and losing in slightly different ways. So it's not talked about as winning a case means getting a client freed from all charges. Winning a case is instead talked about in terms of getting a suitable punishment or making sure the client was appropriately defended and got a fair trial. So they kind of they construct winning in a different way as to perhaps how we would see winning.
Now, obviously, around these defense lawyers, there's a whole team, I suppose, would be supporting them. And you actually talk about the importance of a team. Can you explain what you mean about the importance of the team?
Yeah, I mean, my dissertation then has a sociological starting point, and I have an interactionist starting point. So I see that we are working together to construct our realities, our social realities. And so that the trial itself can be seen as a form of teamwork with with the defense lawyer and the judge and the prosecutor all performing their roles as they should, as they're expected, in line with the expectations linked to their roles, to make sure that the trial runs smoothly. And also within this overarching teamwork that is a trial, there are these smaller teams. So the prosecution team, the judicial team, and then the defense team, which I focused on mostly. And in the defense team, it would then consist largely of the defendant and the defense lawyer. And they themselves are working together to produce a certain impression to the courtroom, to convey a certain reality to the courtroom. And oftentimes that reality is based on the defendant claiming that they have not committed the crime, that they're innocent. So therefore, the defense lawyer's role is about presenting this to the courtroom, and the guiding principle for a defense lawyer in this is that they are loyal to the defendant. So everything they do in the courtroom is based on presenting the client's version of events and their reality of what happened, and doing this in a loyal way. So everything they do is in line with presenting themselves as a team, and basing this presentation of team on the client.
Sounds fascinating. I think, when I read some of your work, and I was totally blown away. I thought, my goodness, I haven't heard anyone talking about the role of emotions in courtrooms, and yet it is absolutely fascinating when you think about what is happening in the US right now, which is going to lead to my next question. But of course, right now there has been this amazing focus on Trump and his different court cases. And, I'm just thinking about these defense lawyers defending something that is quite obvious, and then how it is presented to the world. Now, from your perspective, how do you experience, or what is the problem with the move from traditional co-presence of legal professionals, defendants, plaintiffs, and witnesses in physical courtrooms to the use of video conferences in trials in Sweden?
Yeah, video links, they've been used, internationally. Australia and the UK and the US started to use them in trials a couple of decades ago. Australia in particular are very at the forefront because there were such large rural areas to be covered. So it enabled people to take part in trials. So video links were first used to enable access to justice and also to protect vulnerable witnesses, and been able to be used in Swedish trials since a reform in the early 2000s, which was a more modern courtroom, which was about introducing new technology to make trials run more smoothly and efficiently. And so video links have been used in trials in Sweden since then. And then during the pandemic, in line with a trend that we saw across the globe, the number of video links used exploded. So they doubled, or if not tripled, to enable justice to continue to function, so that people could still take part in a trial, so that trials weren't delayed. And again, this was something that was seen all across the globe. So even countries that weren't using video links started to introduce them. So they are, and now the courts in Sweden have invested a lot of money in the technology. They're included in their strategic plans for digitalization. So they are something that are here to stay. And reports and evaluations show that they are efficient. They can save money. There's other ideas that they're environmentally friendly because they reduce transport. They reduce the risk of prisoners escaping in transit. So that there are seen to be all these advantages. But since the pandemic, there's been renewed focus on video links in courts, and more research being done, kind of going back to the original studies that were done, which were more positive towards them. And now we're kind of seeing more and more problems in that they are being used across the board. So they're being used in all kinds of trials for all kinds of participants. So that there was even a case of a mistrial that was called during the pandemic, as the judge took place via link, and that was appealed and found to be not correct. So they had to retake the trial. But from my sociological perspective, then I think the major problem with using these video links is that it takes away the possibility. If you have a defendant taking part via video link and the defense lawyer sitting in the courtroom, then my focus in my research has been on these small ways of interacting, and for the defense lawyer to be able to appropriately and efficiently defend their client means, in the Swedish context, they need to be sitting next to them to be able to communicate clearly, to be able to read the defendant, but also for the defendant to be able to read what's going on in the room as well. And this is also problematic if it's the defense lawyer taking place via video link. They can't read the subtle cues that are being conveyed in the courtroom. So Åsa Wettergren and Stina Bergman Blix, who have had this a big research project on judges and prosecutors, and showing how they manage and convey emotions in the courtroom. And for the judge, this could mean that they place a pen on the table, and then they are conveying with this, now you've gone too far, to the defense lawyer. So the defense lawyer knows they've broken an emotion rule, they're being too aggressive, they need to tone it down. But if this is taking place via video link, then either they can miss this subtle eye contact that the judge is trying to make, because you can't have eye contact via screens and cameras as we currently stand, and also, quite basically, the movement gestures might be out of shot of the camera, and so you miss them. So it's the interactional components, and in particular eye contact, which is used very strategically in the courtroom to convey information. It's lost. So, and these are kind of the fuzzier, softer aspects that have been kind of looked past and not really included. So this is, I'm going to be starting a research project starting after the summer that's going to be focusing on this and how video links really disrupt, but also trying to lift the benefits of using them, so we get a better, clearer picture of. That was a very long answer, but yeah, I think it's incredibly interesting. I think the problem is that we've rushed this technology into the courtroom in a sweeping way as a solution to the pandemic, without fully reflecting on and really reflecting on, is it suitable in all cases, for all parts of a trial, and for all participants.
I'm just thinking about when you mentioned before that, there is the lawyers, the defense lawyers, and their emotional, how they behave in the actual courtroom. What I found is interesting, because when you mention that, you got to know when a judge put the pen down, it means this. But if you're a defense lawyer, you wouldn't come across the same judge in every case, would you?
No, and I mean, you would have the same judge every now and then, but putting a pen down is just one example. There are different strategies for conveying these emotions in subtle ways. whole heap of problems where if somebody doesn't speak Swedish, then there is supposed to be an interpreter present, and they are supposed to be with the defendant, and this can also lead to more technical difficulties if it's not possible for the interpreter to be present with the defendant. Then it can make it harder to translate. Everything is slightly delayed. There can be slight lagging, which makes it more. It can lead to increased frustration. We also know that things such as the camera placement, how you are framed, which angle you're framed from, changes how you're interpreted by other people. So this can also make you come across in a certain way. As I say, video links, they can change how we interpret and perceive emotions. In particular, something like remorse, which isn't supposed to be included in kind of in judicial evaluations, but it nevertheless plays an important role in how somebody is perceived. And remorse is something that is seen as so important in the courtroom, but we don't actually know how is remorse. How does somebody look when they are remorseful? But we still, judges in particular, studies have shown, think that they know what it looks like, and even in one study showed that they know how it tastes and it smells in the courtroom. So if this is then being done by a video link, then it makes it even more problematic. Video links cause a whole number of problems. There's a very interesting work being done by Carolyn McKay in Australia, who has previously looked at prisoners and how they feel like they do not have the right to participate in a trial on the same conditions as other people when they participate from the prison. So they feel their power has been taken away from them, and not just this, but that they also lose the opportunity for seeing their family and their loved ones in the courtroom.
Yes.
Which is also something that we don't really reflect about. We just kind of think, well, this is a very efficient and good way of making sure we can hold the trial in a secure and efficient way, but it's really missing certain aspects. And also Caroline McKay is currently looking at vulnerable participants and how they perceive and the troubles they have for communicating and the risk for miscommunication as well. So it's lots that we don't know.
And of course I'm thinking automatically on domestic violence victims and the importance for for whether it's the perpetrator or the victim, that they are also like you said, that the family can be present. And this is a kind of a there certainly sounds there of pros and cons for video conferencing. Do they actually save them as well? They would be, wouldn't they?
Yeah, it would, in that all examinations are recorded.
You also talk about live blogging from criminal trials. What does that involve? So are we talking to journalists or?
Yeah, so I've had another research project that's looked at live blogging, which is where a journalist sits in the courtroom and writes updates of what's happening in the courtroom, and they're published directly on news websites. So pretty much all of the major news websites in Sweden use them, and a lot of the local newspapers. In here we have Sydsvenskan in Sweden, they have it, and in Gothenburg you have Göteborgs-Posten, they have it as well. So it's a form of court reporting whereby a journalist sits and writes live updates published immediately on news websites. And this was something when I was doing my dissertation, I started to notice that quite often it would be me and the journalist and not many other people sitting in the courtroom. And it kind of made me interested to look at this. So, and then when I started, first I was interested in looking at how trials are depicted and constructed in these blogs, and how legal professionals and the trial, how it shapes our understandings of them. But then when I got in a bit further, I started to realize that what's being reported from the courtroom can be a word for word direct representation of what is being said and shown and done in the courtroom, which is then published immediately on the website, which means that a witness who by law isn't allowed to participate in proceedings before they themselves have given evidence It means a witness can be sitting in the waiting room, waiting to go in, and can be reading and finding out exactly what's being said in the courtroom before they themselves have given evidence. So live blogs actually constitute quite a major threat to the legal security of trials. And this project that I had compared Denmark and Sweden, and during the project I discovered that Denmark actually has a different law around this. So in Denmark, because there was a trial whereby somebody actually changed their version of events because of what they'd read on a live blog, they've changed the law. So there you can't have these direct word for word representations and descriptions of what's said. You can do a summary, but you can't have exact details. But Sweden, we don't have that. We can still have exactly. So for journalists, they don't. There's no. If the trial is open to the public, which most trials in Sweden are, they can. There are no rules prohibiting them from describing anything. They have ethical guidelines that they should follow, but beyond that, it's free for them. I think particularly finding that they are able to write exactly what's going on. This is a flaw. I think again, the digitalization has enabled that we have this capability of doing this kind of immediate direct reporting without fully reflecting on the consequences. So I don't think the law has kept up with technology there. I think also that I think that the journalists who are sitting there, they are coming from this media. They want to find these things that are going to make a trial clickable, that people are going to want to read about it, and therefore they do dramatize certain clashes, or that it is the clashes between defense lawyer and prosecutor that are reported on, and not the very boring presentation of evidence and the kind of long grey stretches. It's the exciting things which are presented, and also that the legal professionals can be emotionalized, so that they can be described in more emotional terms as angry or irritated. But again, this is a way to attract readers, but on the other side, it is helping to understand the courtroom. If we kind of compare the two different spheres, the media sphere, which is more dramatic and sensational and emotional, compared to the legal sphere, which is a bit more neutral, and emotions should be toned down in order to convey the impression that the courtroom is based on facts and evidence and not emotional, how we feel about the evidence, but the facts speak for themselves. And I think this idea that the facts speak for themselves is correct, but the fact that the understanding that we often have of legal professionals, of them being emotionless robots, it's incorrect. So there's a lot of work being done. Terry Moroney in the US and Susan Band is looking at and trying to really show that judges have emotions too, and we should see them as active emotion workers managing their emotions actively. So this kind of clash highlights that the media in emotionalizing things can also help to break down this barrier of us seeing the courtroom as this non-emotional sphere. So I think even though there is a degree of sensationalization and dramatization, it can also help in a way to see, for us to understand that these are emotional beings working in the courtrooms too.
What do you think about the digitalization? Do you think there should be some sort of law or regulation controlling it?
I actually think that's an incredibly important question. I think not just from, live blogging is just one aspect of how digitalization has opened up the courtrooms. But if we think in the Swedish context, the case that the prosecutor puts together, the förundersökning, this can be made available. So you can email the court emails it back to you for a small fee, and then you have it. And there is no rules for how this can be distributed. You can share it wherever. So Flashback, for example, is a fantastic place to find this entire, like the prosecutor's entire case with evidence that might not even be presented in the courtroom. So in a trial, it's only the evidence that is presented in the courtroom that the judge should consider for evidence. But the entire case can be circulating on Flashback. It can also be obtained by reporters as well, who could also include images and even in live blogs. So they could live blog. I'm not sure if this has happened, but it could be the case that a reporter could sit and write a live blog and include evidence that isn't actually presented in the courtroom. So it shouldn't be. So it becomes this mass of information that is available because of partly because of digital means, but partly because of the fantastic principle that we have in Sweden of access to public documents and proceedings, which is great to ensure open justice and transparency and ensure that everybody is accountable. But I don't think that the law has kept up to speed with these new these new things that we can do because of digitalization. So I sound very negative to digitalization. I'm really not. I think it's a very positive and has a lot of huge benefits. Not least to being able to protect victims of domestic crime who do not want to witness in a courtroom, who want to be somewhere else. So there are these positive things, but I fear that we need to stop and take a good look at them right now. I think it's an incredibly urgent problem.
Now, in 2022, you were rewarded with an excellent teacher title. Can you talk about the reason you sought the title?
This was something that we started. The Faculty of Social Sciences started up, and I firmly believe their reasoning behind it was to lift the status of teaching in line with the status of research. And I completely think that's a fantastic thing to do. I think there is far too much focus on research at universities, and quite often teaching is kind of pushed to one side, and it's almost viewed as if teaching is something you do if you don't have research money. And I think this is an awful way of looking at it. I think we really need to lift the status of teaching to be on a par with research. So this was kind of my driving force to kind of help and contribute towards raising awareness and the status of teaching.
So what do you think makes an excellent teacher?
I think I don't by any means consider myself to be an excellent teacher or any better than any of the teachers at my department. I just sent in an application. So I think I don't think there's anything special about me compared to many of the other teachers we have here. But I think what makes an excellent teacher is that you are aware of, or for me, I think making myself aware of teaching as partly as a two-way process, and seeing that there needs to be interaction between the student and the teacher, and not just seeing teaching as teaching, but teaching and learning in conjunction with each other, and kind of using the students to inspire and each other, but also you as a teacher. So I very much see it as this kind of holistic way of being in the classroom together. And I mean, not just in the classroom, but kind of all the other activities that are included there.
Now you teach in the subject of criminology.
Yeah.
So how do you engage your students, for example, about emotion rule and emotion work?
For me, my research interest is a fairly easy one to integrate into most kinds of teaching. Because I'm interested in how you, I mean, one of the first things that I can talk about with them is the emotional rules of the classroom. So how we interact in the classroom. We know there are certain ways of acting and being, and if you're bored or angry or whatever, there are certain ways of showing it. And we know when we've broken this, when the teacher maybe looks a bit irritated at someone, or the other students look at that student. So I can kind of start to integrate that with them already there, but I can draw on my own research on defense lawyers and talk about the courtroom context and how the rules of interacting, and then kind of draw that out to other areas of interacting. If you are a member of a certain subculture, then you can talk about that there are rules for interacting within these different subcultures that would differ to the wider culture in society. So, and again, I can link in the work of Erik Hannertz, for example, at our department, who's very much interested in subcultures and ways of acting and doing things. So it's quite an easy topic in a way to integrate.
I think it's just, I think that is one of the, if you like, if there is a secret to teaching and engaging with your students, is to actually talk about your own research.
Yeah, no, I think talk about your own research, but also make it, contextualize it for them. So I've taught criminology, but I've also taught on the human resources program, and also psychology, and you can angle it to make it. And again, I mean, everybody has emotions, and everybody has to work with them to make them appropriate. So it's something everybody can really latch onto and start to reflect on.
You know, criminology as a subject is really popular in Sweden. And I do know that there has been a growth in the actual uptake, or students are really keen on studying criminology. What do you think, why do you think that is?
Criminology has massively grown. Lund has the most popular criminology program in Sweden, and we just have the most fantastic students. I think it's because partly, if we're going to kind of see it in a sociological perspective, I think the social construction of crime as a problem, partly by the media, by politicians, but we read and hear about it all the time, and it really has raised the profile of criminology, and we're seeing more and more criminologists who are starting to appear in the media and who are starting to be listened to and taken far more seriously, I would say. So I think that the status of criminology has risen enormously over the past few years, which has led to more and more students wanting to apply for this. And I think as well, it's much easier for a student to understand what a criminologist does compared to perhaps a sociologist, which is more, I mean, understanding how society works and the interactions within and the structures. But whereas criminology, it's more understanding crime and deviant behavior, and it's kind of, it sparks more interest. I think it's seen as more exciting. So I think it's drawn not just the media reporting, the politicians, but also, I mean, you look at any kind of podcasts are all about crime, documentaries, everything on Netflix, everything is about crime. So it really is the place to be at the moment.
So there will be a lot more crime writers.
Yeah, and actually, I was only talking yesterday. My husband is a teacher as a gymnasium, upper secondary school, and we were talking about whether criminology would start to be a subject that could be taught. And I think this will be the next step. Criminology is that they teach it, but I'm not sure it's a specific course, like a subject that you can take. But I think it will start to kind of drip down into earlier, from university down to lower levels of education.
Yes, it's going to be an interesting journey to follow what is happening in the future. Coming back to you, so what are you doing for summer 2024?
Oh, that's a good question. I don't know yet. I have 2 more days left I have 2 days of working with a lot of work to do before then. I have a trip to Stockholm planned in with family from England who are coming just to be able to go to the ABBA Museum. So very, cliched in English, but yeah, that's going to be the highlight of the summer. But then also just mainly staying in Sweden and doing lots of outdoorsy things and gearing up for the ABBA Museum.
That will be wonderful. And midsummer, are you following the Swedish tradition of how long have you been in Sweden?
I've been here nearly 20 years now.
So you're going to celebrate midsummer how?
Yeah, the traditional way. I live in a little village and we have a very big gathering. So we normally celebrate with 4 other families and we gather them for lunch, and then we go down and do the grodor, små grodor, and then the jordgubbstårta, and then we come back and have a barbecue. So it's lots of ritual for us and tradition attached to midsummer. So it's my highlight of the year. So yeah.
Sounds wonderful. Listen, I want to thank you so much. It's been wonderful talking with you, and of course I hope to invite you back maybe later to further talk about what is happening with digitalization and the exciting areas of criminology and court cases. And look, thank you so much.
Thank you very much for having me.
And you have been listening to the podcast Sånt är livet i Sverige, or in English, That's Life here in Sweden, with me, Lisa Åsimäki. Till next time, take care of yourself and each other. Bye for now.